have everybody. Committee, today we're going to work two bills. We are not going to work HB 2253, which had to do with livestock. Just there's probably too much work that needs to happen with that bill. And so we hopefully will get to it maybe next session. And we know there are some enthusiastic representatives about that bill. And so we will see what we can get done about that. But we will go ahead and work these other two things. We'll start with HCR 5008. And let's see what discussion we may have on that. Well, first we'll ask Jason to give us it's actually been quite a while since we had that. If you could remind us what that is about, we would appreciate it.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. This is the concurrent resolution that would put a proposition to amend Article 2 of the Constitution on the ballot. This would be concerning administrative rules and regulations and provide for legislative oversight. I won't go into too many of the details there. It just provided that the legislature could, by law, make a process to approve regulations and also propose amendments to existing rules and regulations, and had some criteria for how the legislature might evaluate what is obsolete or unnecessary. And it would go on the ballot in August of 2026 if adopted by the 2/3 constitutional majorities that are required.
Okay, thank you. Committee, what discussion do we have?
Chairwoman, I have an amendment.
Okay.
Not ready yet?
Lewis, we'll hear the amendment and then go to Representative Carmichael after that.
So I'd like ask the revisor to pass the amendment out. And while he's doing that, I'll briefly explain it. So this is a concurrent resolution which would put a proposed constitutional amendment on the ballot, and in essence would give the legislature simple majorities in both houses the ability to revise or revoke regulations or rules set forth by administrative agencies. Without going into great detail, I think a lot of people are concerned with the explosion of the administrative state in the last, really since the 1930s, and think that too often the non-elected administrators in the agencies are writing laws into the books that don't necessarily accord with the will of the people or the elected officials that are elected to represent them. So that's the gist of what this amendment's about. My revision or my amendment is designed simply to simplify the language and make it clearer as to what's really happening. It takes out, as you see, all of the criteria which would ground a revision or revocation of a rule or regulation. And it simply says the essence of it is that the people's duly elected or appointed representatives and senators may revise or revoke administrative rules and regulations or any portion thereof by adoption of a concurrent resolution. And I'll just end by kind of walking you through the process as I understand it. When there's a rule or regulation proposed by an agency in Kansas, it's reviewed, I believe, by the Attorney General, and just to make sure that basically the procedures are followed and so forth. And then it goes to a joint committee of the House and Senate who reviews it but has no authority to order any changes or rejection of the rule or regulation. They're simply an advisory body. And so what this amendment to our Constitution would say is that, no, the elected representatives would have some oversight ability, put some teeth in our oversight ability, and we would be able, if a rule or regulation were promulgated, that the elected representatives disagreed with, they could either revise or revoke it.
Okay, does anyone have any questions about the amendment, or is it about the bill? About the amendment. Okay, Representative Osmond.
Thank you, Madam Chair. Question for the reviser. A House concurrent resolution or a concurrent resolution does not need to be assigned to a committee, but can go to the floor as a debatable resolution. Is that correct?
Madam Chair, I believe that's right under the rules. But yes, I believe the procedure for that is determined by the rules of the chambers. You know, they only require a simple majority. I do know that.
Thank you. So under this proposal, it would be possible to overturn administration's rules and regulations without any discussion or proponent testimony as to why those rules and regulations are good or necessary. That's not a question. I think that's more than just a statement. I'm just trying to wrap my head around how this might be implemented were it to go into law.
The history that I know of, if I could answer, maybe, just being in the legislature, if there's a resolution that is at all, if it's not just, you know, naming someone as something special, if it's substantive, it's been the habit of the speaker to assign it to a committee. I don't know that is it in the rule? I should know if it's in the House rules. Right now I'm a little bit confused. Representative Carmichael, do you have any clarifying statement?
Yeah, let me see if I can address that question, then I will want to address the amendment separately. But the general practice always is if the speaker determines that a resolution is non-controversial, then the speaker does not typically refer that to a committee, but rather it is heard just on the floor, sometimes part of committee of the whole and sometimes just part of the full House. But the speaker, and the speaker can take anything that's in committee of the whole, and if we vote to take it up, we take it up without it ever going to a committee. But the usual practice is if it's of a quote-unquote controversial nature, it goes to a committee, and hence we have one in our committee. That's kind of my recollection.
Yeah, exactly. That's what I'm. Okay, Representative Carmichael.
Yes, on the amendment, and I would like to address the principal bill after we've disposed of the amendment. A question for Mr. Thompson with the chair's leave, and if he's not prepared to answer it, that's fine. But how is this amended resolution, or this, how would the bill be different from what the voters rejected 2 years ago if we were to pass this amendment? Because I know the principal resolution has different language and criterion, and this looks very familiar. Is this different than what the voters rejected? If you know, and I know you may not. I don't know off the top of my head.
So Representative Williams has the language, or Jason, either one of you could read it. The language is quite different.
Okay.
But maybe okay, so Representative Williams has the language.
And I know the explanatory statements are probably different, but the actual operative language is what I'm concerned about. Yeah.
I just have the explanatory statement of how it's different. Yeah.
Oh, okay. Yep. So we'll pull that up and see.
Okay.
Because, yep, the language was,
Would you like for me to go ahead and address the amendment on the merits then?
yes.
You know, this might not be bad at all, because this is very close to the kind of language that got this idea beat the last time we took it to the voters. And so if we want to put in all this flowery language about the people's duly elected or appointed representatives and repeat that over and over, voters are going to remember that from the last time around. And I think it'll contribute toward defeating this resolution. And I certainly intend to support this fine amendment.
Jason, do you have the language from 2022? Thank you.
Thank you, Madam Chair. So the enrolled concurrent resolution HCR 5014 that would have added section 17 to Article 1, so different placement, but that's not really the important part. It was titled Legislative Oversight of Administrative Rules and Regulations. And the text was, whenever the legislature by law has authorized any officer or agency within the executive branch of government to adopt rules and regulations that have the force and effect of law, the legislature may provide by law for the revocation or suspension of any such rule and regulation, or any portion thereof, upon a vote of a majority of the members then elected or appointed and qualified in each house.
Thank you. That refreshes my bad recollection, but I still think this is a great amendment. I'm going to vote for it.
Committee, do you have any other questions on the amendment? Representative, would you, I'm sorry. Okay, y'all really need to just wave big, okay? I don't want to miss anybody, but sometimes I do. And I'll have my ranking and vice make sure they're looking around too. But yes, feel free to, however you can get my attention. Representative Vaughn.
Thank you, Madam Chair. So looking at some of the things that you've taken out here, it includes the reasons by which the legislature may revoke or suspend. And admittedly, I thought a lot of that language was overly broad and created the concerns we previously talked about around judicial scrutiny. So I don't really love that language, but by taking it out completely, you've basically opened this up completely to political interpretation. So there are no guidelines by which a law may be, or a rule or reg may be revised or revoked. It is just the will of the legislature, which I find really problematic since the goal of rules and regs is to serve the public interest. So I guess I'm just wondering, what was the purpose of eliminating all of the guidelines by which the rule and regs would be considered for revision or revocation?
So,
Representative Lewis.
thank you, Madam Chair. So really what this resolution is about is who's in charge, you know, and are we a democracy where we're going to have the elected representatives in charge, or are we going to cede that power to unelected administrative agencies? So the criteria really didn't make a lot of sense in that context.
Representative Vaughn.
Thank you, Madam Chair. I guess my counterpoint to that would be that the governor is also duly elected, and the governor is elected to run administrative agencies that establish these rules and regs. And by passing something like this, we're undermining the ability of a duly elected governor to carry out her responsibilities and duties.
Okay, Representative, would you like to move your amendment?
Yes, do we have a second? Did somebody second?
Yeah, but you have to move first.
Oh, thank you. Yes, I move my amendment.
Seconded by Representative Barth. Okay, any other discussion on the amendment? And Representative, you may close.
I close.
Oh, I'm sorry. Representative Carmichael.
I just would observe, now that I've had a little bit more opportunity to look at this, that the explanatory statement that starts at line 8 on page 2 is in many ways inconsistent with the actual substantive language on page 1. So far as I can tell, as amended, or as this amendment would make the bill, there's no mention at all about any burdensome regulations or any whys or wherefores. And yet, when this goes to the voters, they're going to read some statement about accountability, transparency, unnecessary regulations, burdensome regulations, not beneficial to the public good. None of those rules are a part of the substantive portion, or none of those explanatory statements are a part of the substantive rules in the actual statement itself. So the explanation doesn't match what we're enacting into law. And so we're intentionally or otherwise misleading voters, and that's not a good idea.
Madam Chair.
Representative Lewis.
I respectfully disagree. I mean, the explanation is the purpose for the amendment. The amendment typically, just sets forth the powers of the relative agent, actors in this instance, but this does set forth the purpose for it, and it seems to me perfectly right that it should.
Any other questions or comments on the amendment before we vote on it? Okay, and Representative, have you closed?
I close.
Thank you. Okay, you've heard the amendment, the Lewis Amendment to House Concurrent Resolution 5008. All those in favor say aye.
Aye.
Opposed, no. Okay, the amendment will be put on
In this instance, I would
HCR
like-
5008. And Representative Carmichael had a yes vote that he would like recorded.
A proud
Any
yes vote.
Any other committee members would like a vote recorded? Okay, so now we are on the concurrent resolution. It has been amended. House Concurrent Resolution 5008. What discussion do we have? Representative Carmichael.
Thank you, Madam Chair, and I don't want to step in line in front of Representative Bourgeon, but I really did have my hand up a little while ago on this, so I appreciate it. I may have made a partially inaccurate statement when we were actually hearing the bill. You may recall that Representative Wassinger testified, and I recalled part of the story. The part of the story that I recalled was that a lot of this came out of a Department of Labor regulation having to do with the Workers' Compensation Act. And there were about 6 or 7 specific provisions, regulations, Department of Labor and the Workers' Compensation Division had set up. And I had said that the day before the hearing or before the hearing that the Attorney General revoked his approval of one of the regulations. And Representative Wassinger said, no, there were 3 of them that were revoked. And the representative and I did visit a little bit later, and no matter who knew what when, it was correct that first there was one regulation that was disapproved after the Attorney General had approved it. And then after Representative Wassinger visited with the Attorney General, according to her report, and I believe her, but after the committee, the Rules and Regulations Committee had heard the regulations, then Representative Wassinger talked to the Attorney General's office further, and then they issued 2 more revocations of their prior approvals. I just want to try to make sure that I've laid out what happened accurately, because I didn't know those additional facts when we were discussing the bill, and Representative Wassinger and I think are in agreement that's what happened. Here's why all of that is important. This is in fact unnecessary, this resolution, because I would suggest to you that the system worked exactly as it was designed, particularly with respect to the flagship, if you will, event, which is often cited as the reason for this resolution. And that was these Department of Labor workers' compensation regulations. The law currently is very clear that if the Attorney General concludes the agency is overstepping their legislative authority or acting without legislative authorization or proposing a regulation that is in contravention to existing case law, that the Attorney General shall not approve the regulation. If the Attorney General doesn't approve the regulation, that is the end of it. The regulation doesn't even go to the Rules and Regulations Board. And those of us who serve as chairs or chairs or ranking members, we get a raft of letters from the Attorney General about disapproved regulations. We get them with regularity that the Attorney General says they don't meet one or more of those 3 criteria that I just described. So that's the first step. And this situation with Department of Labor would have never happened, quite frankly, if the Attorney General's office hadn't been asleep at the switch for some reason. I'll tell you, I looked at those regulations in advance and I thought 3 of them were beyond the authority of the agency. And I told the agency that myself, and as it turns out, those are the ones the Attorney General revoked the authorization for. The remaining regulations were never pursued. The Joint Committee on Rules and Regulations made their opinion abundantly clear, and the agency, Department of Labor, said, we're just not going to go forward with these. They didn't even hold a hearing, as I recall. They never became law. The system worked, despite the fact that the Attorney General approved some regulations, which in hindsight, the Attorney General realized he should not have approved. And I think it was Derek Schmidt, by the way, at the time, rather than the current occupant of the office. So the point of it is, this statutory scheme works. The second thing that we never got to in those Department of Labor regulations was the legislature can revoke any regulation by means of introducing, passing a bill and submitting it to the governor, and if necessary, overriding the governor's veto. That Department of Labor regulations, they never got to that point because the system worked the way it was supposed to. In fact, what happened was it was the jumping off point of a very successful bipartisan effort that we all celebrated last year. Not all of us, but those of us who were here. I think we voted for it virtually 100% and celebrated it last year. We got to the right result. So, to try to wrap this up, this is simply unnecessary. And it's been the law of Kansas since, I think, 1982. Ex rel Stephan on relation of Robert Stephan against the Kansas House of Representatives was the case. And it found that no, you can't revoke regulations without submitting it to the governor for signature, veto, passage without signature. And this resolution would go around that requirement, but it's never been a problem. We've revoked the regulations that weren't a good idea. We can do that by statute, and this has never been a problem. But now we have it very clear that this is a part of a grander scheme against rules and regulations. I personally don't think the voters will be fooled, but I'm certainly not going to vote for this HCR. Thank you. Sorry I couldn't be more concise.
Representative Bourgeon.
Thank you, Madam Chair. I'm not seeing a fiscal note in the system for this. Do we know what the cost is to put this on the ballot?
We do not know.
It's not free.
No. So it's not a special election, and it's on the ballot and the general, or it's the primary, I think.
Yeah, I
in
think I
August.
misspoke. Technically, it's a special election, but it's held at the same time as the primary.
Yep.
So we're talking about printing a little bit more space on a ballot and counting one more question.
Okay, thank you.
Yeah. We could probably ask for a fiscal note if we do pass it out and want it and before it goes to the. Any other discussion on the resolution? Representative Lewis.
Yeah, I'd just say, and I suspect that most everybody in this room, even the newer representatives, and I'm relatively new myself, but nonetheless, I suspect you have gotten a number of calls from constituents complaining about a rule or regulation and wanting you to do something. And it may have to do with inspections of elevators or fire department regulations, which seem kind of minor but are very important to your constituents. And I just don't think it makes sense that we have to then go through the process of rewriting a law or a law where the legislature looks at that rule or regulation and say that's crazy. And the rule of regulation, let's be clear, was not legislated. It was dictated by an unelected bureaucrat. And I don't think it's unreasonable that the majority in both houses should be able to revise or revoke it.
Representative Schreiber.
Thank you, Madam Chair. The issue that I've got with this concurrent resolution is, and many of us have dealt with regulators here in the state for many years, that if the legislature starts kind of picking apart regulations in whatever department, wildlife and parks or commerce or wherever, the folks that have to implement those regulations, if we change one regulation, it might change some more of theirs and cause more difficulty for keeping the body of regulations consistent across that particular agency. I'm not saying that would happen every time, and not that I like every regulation that's out there, but I think this has the potential then to disrupt this body of regulations out there to keep it consistent so people do know what they need to abide by when they're looking at the regulations for their business or personal interest. And so with that, right now I can't support this concurrent resolution. Thank you.
Representative Barrett.
Thank you, Madam Chair. And I kind of want to share the same sentiment as Representative Lewis. You know, I'm sure all of us have gotten emails, for example, like on KDADS with COF is a huge group in my county where they're serving the intellectually disabled and they're doing some really great work. And then KDADS comes out with a regulation, short-term rules change that could put them out of business and change how they do their business. And so, again, I'm sure in the 80s, whenever the last change happened, the amount of regulations and how burdensome this has become these last 10, 20, 30, 40 years is just unimaginable. And so I'm in support of this. And additionally, according to my notes, at least one of the proponents had stated it as well, is that we're only one of 16 states without some kind of oversight from the legislature. So I think this is a good bill and I support it. Thank you.
Anyone else? Mm-hmm. Oh, sorry, Representative Vaughn.
Thank you, Madam Chair. I mean, per my, comments, I'm not in support of the bill, but something else was raised today that I unfortunately did not have an amendment prepared. I know you're not generally in favor of conceptual amendments, so I could bring it on the floor, but I think the other problem with this is that by having it in a primary election, we're putting this on the ballot of a low turnout election that disenfranchises the majority of Kansans from being able to actually weigh in on this issue. So if a conceptual amendment were to be allowed, I would think it would make a lot more sense to have this on the general election ballot November 3rd, 2026, to empower more Kansans to weigh in to make this decision. Just like they did the last time. So if that was allowed, I would be interested in that conceptual amendment because I think that enables a lot more people to make this decision.
Yeah, thank you for that, Representative Vaughn. It is my practice not to allow conceptual amendments for the new people on the committee. I feel like Judiciary is really the kind of committee that we need to have a little more background thought. But I do understand that, that's a simple amendment. I think that could be something you for sure could bring on the floor if this passes out of the committee. And I would encourage you to do that if that's something that you would like to do, because it's simple. Clearly, it's germane. And so
I'll hold you to that, Madam Chair.
Yeah. Okay. Any other discussion? The last thing I would like to just remind the committee is that, so this is, I think everybody knows, but I want to make sure before we vote, or even have a motion, House concurrent resolution, it's to put this language on the ballot so that the people can vote. It will be a majority vote of the people. But it takes 2/3 of the House and the Senate to put it onto the ballot. Just so you all know. I do think this is important. because we know we have had many burdensome regulations, and they often do have the force and effect of law. And they're not laws, they're rules and regulations. And so to have some sort of legislative oversight, I feel like is wise. Or, and even I wonder if it would help the agencies as they're thinking through rules and regulations, knowing that they're going to be able to be revised or revoked by the legislature. They may be careful in their rulemaking and in their regulation making. So just with those thoughts, Representative Williams.
Thank you, Madam Chair. I move that we pass out HCR 5008 as amended favorably for passage.
We have a second. Representative Lewis seconds. Okay, I'll ask one more time, any discussion on the resolution? Okay, since seeing no discussion, any further discussion, we have a motion and second to pass House Concurrent Resolution 5008 favorably for passage as amended. All those in favor say aye. Aye. Opposed, no. The ayes do have it. Yeah, and we now have division. All those in favor of the House resolution, please raise your right hand. Okay, and all those opposed, raise your right hand, please. Okay, by my count, 9-7, the motion passes.
May I have my negative vote recorded?
Yes,
please?
Representative Carmichael, no vote. Anyone else like their vote recorded? Okay. Representative Martinez would like her no vote recorded. Anyone else? Okay. Thank you, committee. We will now move on to House Bill 2347, and we will ask our reviser, Jason, who I hope gets a little bit of a break in the next few days since he's worked so hard for us, to tell us about House Bill 2347.
Thank you, Madam Chair. Jason Thompson, Revisor's Office again. Yes, House Bill 2347 deals with the crime of theft. It has two parts. One, changing the culpability requirement from the knowing property was stolen from another to knowing or having reason to know property or services were stolen from another. And the second part, increasing the penalty to a severity level 10 non-person felony when the property that was the subject of the theft is a motor vehicle that is valued at less than $1,500.
Okay, committee, let's talk about House Bill 2347. Are there any amendments? Representative Carmichael.
Thank you, Madam Chair. I have an amendment which with your leave, I'd like to have passed out or distributed, and I can tell people about it at the same time if you wish. As you might recall, at the hearing on this bill, we had discussions about two things. The first part of the bill changes, to some extent, the culpability standard for auto theft from knowing to instead saying have reason to know, as I recall. No.
That's right.
Okay. And the second part, it moved this from being a misdemeanor offense to a felony. And during the hearing, we had discussions with Ms. Jarman from the City Attorney's Office, the law enforcement advisor at the City Attorney's Office in Wichita, about whether we were defining this properly, because they understood they didn't want to encompass vehicles that were really scrap metal. At the same time, then we got into discussion of operable vehicles, inoperable vehicles, registered vehicles, unregistered vehicles, and vehicles required to be registered. I think that kind of covered the waterfront. And so with the chair's assistance, we got in touch over the weekend. The city started working on this. And by the time they had worked through the issues, they sent me back a draft that said, let's just stay with the with the misdemeanor offense rather than advancing this to a felony. And let's keep the existing language that's in the law. In other words, don't worry about redefining what kind of a vehicle. And so that was the decision on their part. the reciprocal part of it is, I'm not going to argue at all about whether reason to know should be or should not be in there. So that's all this amendment does. If you want me to address one other thing on the merits is, I don't know for sure that the city thought of this, but I thought of this later on, that on crimes like this, misdemeanor crimes, there's concurrent jurisdiction between a municipality and the state, which means that the city can pass an ordinance to prohibit conduct if it's a misdemeanor. But generally, the city can't pass ordinances that constitute felonies. Felonies, by the simple definition, subject you misdemeanors up to 1 year in the county jail. Felonies is state penitentiary. And if you codify this in state law as a felony, then that may impinge on the city's ability to continue to have a city ordinance to prohibit the same kind of conduct. Now, I haven't thought this all the way through. I see my friend Mr. Klump looking at the ceiling. But I think what could have happened too is, if we'd have passed this in the form it was originally introduced, the city would no longer be able to charge these crimes. It'd have to be charged by the district attorney, because that's the specific crime of theft of a vehicle under $1,500. And then you wonder whether the district attorney or county attorney will file complaints over $200 or $300 or $400 thefts. So that's a long way of saying this is what I believe the city of Wichita, actually it's the language they sent me virtually unsolicited, and I said I'd send it to the reviser.
Does anyone have any questions about the amendment? Representative Vaughn.
Thank you, Madam Chair. So just to confirm, it changes the felony back to a misdemeanor, but keeps that language of reason to know? Is that
Right.
Okay, thank you.
Yeah, it just strikes out the language that would have made it a felony. Instead, it's
Correct.
just staying the way it is now. Yep. Okay, any other questions? Representative Barrett.
I guess more of a statement. So I'm glad we're keeping the language back in there. Making it a felony, I think, does give it, I understand you will have to run it through district court. City courts can't run it. But it seems to give it more teeth, because for us, maybe a $1,500 car or $1,400 car doesn't mean anything. But to that person, that's their only mode of transportation. And when it comes to investigations, usually your property crimes, when it comes to the investigations division and bigger agencies, is going to be split between misdemeanor and felony. So you're going to have maybe more of a priority if that is a felony crime. At the same time, I do understand you are putting a bigger burden on the district courts by making it a felony. I mean, I'll support the bill either way, but just I'm kind of stuck on that point right now.
Any other questions or comments about the amendment? A little bit of clarification. I will say that I think the main purpose of the bill was the having reason to know. And then this other piece, there was a little bit, there were different, as we heard, ways that we could determine registered, not registered. So it doesn't keep us from working further on that, maybe, next year or whatever, after we have a little more clarification. So, yeah, that's my 2 cents worth, and the city of Wichita was okay with it. Representative Barrett.
Okay, thank you for that clarification too. And like I said, I'm glad the language is in there, and since Wichita's for it, I'll go for it. Thank you.
Would you?
I mean, if I could clarify, since the bringer of the bill
Yes.
believes that this fits their need, then I will be for it in this instance, and doesn't mean in the future. Thank you.
Representative, would you like to move your amendment?
I move adoption of the amendment before the chair.
Do we have a second? Representative Osmond seconds. Okay, any other discussion about the amendment? Okay, you've heard the amendment on House Bill 2347. All those in favor say aye.
Aye.
Opposed, no. Okay, so the House Bill 2347 is amended. Now we're back on the bill. What questions or comments do people have about the underlying bill? Anything? Representative Curtis.
Thank you, Madam Chair. I move that we pass out House Bill number 2347, favorable for passage.
Do we have a second? Representative Schreiber, did you raise your finger? Representative Schreiber seconds. Okay, any discussion on, any more discussion on House Bill 2347? Representative Goddard.
Just a question on the motion. Should that have been as amended?
Thank you for that.
As amended.
And second, are you okay with the motion being? Thank you for that point. Any other discussion? Okay, seeing none, we have a motion second to pass House Bill 2347 favorably for passage as amended. All those in favor say aye.
Aye.
Opposed, no. Okay, the ayes have it. We have passed House Bill 2347 favorably for passage. And committee, you.
Madam Chair, would you record
Yes,
my
a yes
affirmative vote?
vote. Absolutely. Anyone else? Okay, so committee, congratulations. You have finished your first half of the session. And we did a lot of really great work. I so appreciate everyone's cooperative nature and staying late last week, especially when we needed to. We will be getting some Senate bills back, and then we have maybe a few bills that have been or will be blessed, possibly, that might be coming back to our committee. So thank you, everyone, for all your hard work, and it's been great, and we're adjourned. Thank you.